The House Oversight Committee will come to order. Madam Clerk, can you take attendance?
Chair Johnson.
Here.
Representatives Outman.
Here.
Boydenka.
Here.
Riley.
Here.
O'Malley.
Here.
Wozniak.
Here.
Brixey.
Here.
LeGrand. Young.
Here.
Mr. Chair, you do have a quorum.
Thank you. With that, Representative Outman moves to adopt the minutes from the March 18, 2021 committee meeting. Without objection, the minutes are approved. All right, it is April 15, 2021, and still the unemployment offices are still closed. Hopefully we can get those open soon. Hope you guys enjoyed your spring break, getting ready to get back to work here. I know a lot of the staff of the governor's office enjoyed their spring break. Hopefully maybe they learned some good freedom-loving things down south that they're going to bring back here. It is interesting that DHHS won't testify before our committee, but they did have time to go on spring break. All right, we are going to move on to House Bill 4448. This is dealing with FOIA during a state of emergency. We have Steve Deli with the Michigan Council on Open Government wishing to testify via Zoom. Steve, are you on?
I am. Thank you, Mr. Chairman. I'm here to testify on behalf of this bill. It's straightforward, but it's a very important bill. Throughout the pandemic, many organizations and even just regular citizens have had a tremendously difficult time getting records. And I have one example in particular that I think really shows why this bill is important. As the committee is undoubtedly aware, Executive Order 38 last year suspended ordinary processing of FOIA. That occurred early with March or April, I believe. The purpose of that suspension was originally to allow delayed processing of FOIAs while ordinary business practices were suspended. That didn't last particularly long. It was rescinded in June by Executive Order 112, but our local municipalities and public bodies took that opportunity and really ran with it. So we filed a FOIA request with the city of Detroit in August of last year, so at least a month after the temporary suspension had been lifted. And Detroit said essentially, well, it may have been lifted, but we're not back to ordinary business practices yet. So despite the fact that there is no order in place allowing us to continue to delay our responses, we're going to continue to do so. And we have not heard back further on that FOIA request since September. And it's those kinds of practices that I think this bill helps to prevent, and it's those kinds of practices that I think make this bill absolutely necessary. Thank you.
Thank you. I don't see any questions for you. Thank you for your testimony this morning. I know based off of, we had testimony that's, I think, 4 or 5 weeks ago at this point, there was some talk about what if there was a flood and then a fire, whatever. So there is an H1 sub. Rep. LeGrand got me some language, and that it adds to it that they have to perform the FOIA as normal unless the public body establishes by clear and convincing evidence a physical inability to comply with those duties as a direct result of the declared state of disaster or emergency. So essentially, the burden of proof would be on that local unit of government by a clear and convincing standard. We think that's an appropriate standard in case of that very rare instance. We are going to adopt at H1, but I'm going to give LeGrand a few more minutes to get here. So we will move on to House Bill 4591 with Rep. Roth. And we took testimony on legislation similar to this before spring break with Rep. LaFave and Rep. Glenn. This, I think, is a more comprehensive bill where it's not just the executive branch, but it's the legislative branch as well. We are working on some possible amendments to it, so we are not going to vote it out today. But with that, Rep. Roth, you want to come up and testify about this great piece of legislation?
Thank you, Mr. Chairman and members of the Oversight Committee. I appreciate being here today to share this with you. Mr. Chairman, it is pivotal that our state work for the responsible fashion for taxpayers in Michigan. Their hard-earned money must be used wisely and effectively here in Lansing. I feel this is our charge as representatives and of the people and the stewards of the state of Michigan to spend wisely. I felt this way before I was a public citizen and before I was a legislator. I truly believe that. This legislation before you ensures the severance packages to state employees in both the executive and legislative branches are fair, transparent, and the best interest of citizens of Michigan. The bill has clear stipulation, lays out a clear process. The state would be prohibited from giving state employee and state officers more than 12 weeks of severance pay, and could not prohibit them from sharing factual information about illegal violations of the law. We should never have circumstance where an individual is dissuaded or prohibited from coming forward with this type of information. That is not good for government practice, and people lose faith in their leaders when this happens. There would be a limited exception to the 12 weeks limit to the state employee only if the Attorney General or Legislative Council, depending on which branch of government the employee belongs to, determines the payment above that amount is necessary to save taxpayer money and best serve the state interest. And such payments would only be allowed in exchange for release of all claims against the state. The bill also contains reporting requirements for all severance packages that exceed 6 weeks of an employee's normal wages. It requires key information to be made available online and to the chairpersons of the House and Senate Committees on Appropriation. This information includes the amount paid and the title of the employee's position. Prudent use of taxpayer money should never be a partisan issue. Recently, we've heard about severance contracts and amounts that far exceed what's in this bill. The background surrounding these agreements has been murky. But let's be honest, they're far from the first time this situation's happened in the state. So let's not allow that to occur again. Our constituents rely on the notion that we're using their tax dollars wisely. I believe this bill will help ensure that, regardless of who's in power, that we will make sure it's transparent and good for citizens. Thank you again, and I'm definitely open to any questions that you may have of me.
Thank you
Thank
for
you,
your
Mr. Chair.
Thank you for your testimony. I believe Rep. Outman has a question.
Thank you, Mr. Chair, and thank you, Representative Roth, for bringing forth this critical legislation. Anything that increases transparency, I'm all in favor of. I guess my question for you is, how unusual are these types of agreements within government, and specifically the non-disclosure agreements? I mean, in normal circumstances, it's used to, protect trade secrets and intellectual property, within the business world. But within state government, how unusual are these types of agreements?
Fairly unusual. It's not just current, but there have been in the past also some
Sure.
non-disclosure agreements. But in government, it's pretty unusual that you would have that kind of agreement.
Yeah, and you mentioned, in the past we have utilized this even within the legislature, but not to the extent that we've seen within the executive branch here in, recent history. But I just wanted to kind of get your, pick your brain and see if you've looked into this and how unusual it is specifically within state government. So I appreciate your response.
Absolutely, and it shouldn't matter whether it's legislation, or legislative group, or the administrative group. I
Yeah.
don't care from either one.
Sure, and I would agree with that. So no further questions. Thank you.
Thank you.
Thank you for that. And even though he showed up late, I will still let him ask a question. Rep. LeGrand.
I will have my mother give me a note. Thanks for bringing this forward, and I just wanted to sort of make a broad comment, which is, we all know one of the problems of being in politics is we're held to the standard of perfection, right? Like, we're all supposed to never make mistakes, and I make mistakes all the time, and I make at least 8 a day that I notice, which means I probably am making 20 mistakes a day. I'm not perfect. None of us are perfect. I personally think this has sort of been a great learning experience for our entire body, which is to say, the governor had an NDA on an employee. There was lots of publicity, and then she thought, right, I shouldn't have done that. So she has a policy that she won't do it in the future, but that doesn't bind future governors. It's not going to bind it in the future. So I think it's a great idea to have a clear policy in place that covers whoever's going to be governor next, because Governor Whitmer can't bind the next governor. But similarly, and I really appreciate Representative Johnson for being very clear on this, because he's real clear on these kinds of things, that we have to have a what's good for the goose is good for the gander principle. And so if we're going to do something to the legislature, to the governor's office, we should do it to ourselves too, right? Like good government's good government, good transparency is good transparency. We don't want to whitewash things. And I think it's okay to admit, yeah, looking back, we have done these things too, and it probably wasn't a good idea. And I don't mean we, like anybody on here signed an NDA, but we represent this body and its history in some sense, and we can do better. And so I think this is a great opportunity for us to step forward, up our game, and up our game for the citizens of the state of Michigan. And I think, if you'll allow me one more political comment, I wake up every morning really worrying about our democracy. And I worry about it because if the voters don't trust us, representative democracy is not going to work anymore. If they think that we are here to self-enrich, to make secret deals, to cut backroom deals that aren't in their interest, we're going to have direct democracy. We'll have to be like Amazon. Everybody gets up in the morning and votes on things. And we might just want to get rid of representative democracy, but if we don't want to get rid of it, we better make sure it works. So I really thank you for this. But for me, this is thematically part of two things. One is making sure that I honor and respect my Republican colleagues every day and point out that we are all here for the common good. And the other is making sure that we are accountable to the people and solving that trust problem, because all of us agreeing we're trustworthy in a bubble doesn't do the voters any good at all. I trust you, but that doesn't mean the voters should trust you because I said so.
Right.
So thank you, and thank you, Sheriff, for bringing this up.
Appreciate that, Representative. I really do, and I truly believe that. And I think the package of FOIA information that we've sent on and passed, I think this fits in nicely with the whole package. And it was bipartisan, and I think it's wonderful that we're doing that.
And if the information doesn't get back to the voters, what good is it, right? If we can't be transparent with the voters, we don't deserve to be here. Thank you.
Agreed. It doesn't matter if you're a Republican or Democrat, trust in government is at an all-time low. And so hopefully this will help restore some of that trust on both sides. Representative O'Malley.
Thank you, Mr. Chair. First of all, amen to the representative. Just an FYI on this discussion of non-disclosures, I did send a letter to the Auditor General, who I refer to as the Switzerland of the Michigan government, to see exactly, to Rep. Outman's question, how many of these non-disclosures have we had in the government over the last many years. So hopefully they get that answer to us in a fairly timely fashion, and I'll make sure this committee is aware of it.
Thank you for that letter. Representative Brixey.
Thank you, Mr. Chair, and thank you, Representative, for bringing us the bill. The last bills that we heard on this were really only impacting the governor and not policing ourselves. And despite the fact that the Speaker had introduced that policy, of course, it's something that could be changed at a moment's notice. So conceptually, I like what you're doing, and like my colleague, Rep. LeGrand, I appreciate that what's good for the goose is what's good for the gander. And like my colleague, Representative O'Malley, I too wondered how many of these things, were out there, and the importance for us to make this legislation apply to ourselves is extremely high, because the Senate has entered into $632,000 worth of agreements over a 10-year period, and it covers 30 agreements, and 20 of them have been in the last 5 years. So, that's a lot of money, and that's our employees. That's our legislators' employees that are being impacted. So one of the concerns that I have is for the employees, and how do we make sure that we're protecting our employees? As a Democrat, that's kind of one of my core values, is making sure that people have safe workplaces and are protected. So that brings me to a couple of issues that I have with the way that this bill has been drafted. So the governor's side, the governor is going to have the ability of these agreements severance agreements to be waived if the Attorney General deems that it's in the best interest of the taxpayer, right? So an outside office is regulating the governor. But for us, the majority party is regulating us. And I think given that, you know, the history of what has been going on in the Senate in the last 5 years, I mean, we're talking about stuff that's basically happening now. The majority party being able to waive the severance agreement, well, we're policing ourselves, that means. And so that's a totally different standard, and one that is a loophole that's so gigantic, you know, you could drive a Mack truck through it. So that's problematic. I hope that you'll look to address that. One way that you could address that would be to have an outside nonpartisan body look at and evaluate whether or not those agreements could be, whether that 12 weeks cap could be lifted. Okay, then the other issue that I'm concerned about with this bill is regarding the civil service employees. And so, you know, the way that I read the bill, there's some exclusionary language in there that for those of us who are not attorneys, in layman's terms, says basically we think there might be some issue with the civil service, so if we can't really regulate the civil service, then it doesn't apply. We're not doing our homework. I mean, our job is to pass legislation, and rather than rush things through, we need to be deliberate and take time to figure it out. Is it constitutionally acceptable or is it not? We have attorneys that are being paid on staff with taxpayer dollars. We need to figure out the civil service piece and not enact a law that says, oh, well, if the courts decide that this isn't valid, then it won't apply, right? So that piece, I think, needs more work. And let's see, did I have one more issue? I think that probably those are my two biggest concerns. So hopefully you would be willing to work on both of those issues.
Yeah, I'm just going to step in real quick because we are working on amendments on this, but it is clear severance agreements under this bill cannot be waived. That's number one. Number two, House rules and professional code of conduct for the general counsel for the House, when it comes to legal issues, he owes his duty to the institution, not the majority. And in my experience, lawyers, they're pretty good at representing their client in that regard. So I think that's an important distinction. But we are working on amendments. I know we've been in talk with the governor's office on this very issue. And that's why we're not voting out today, even though I really wanted to. We're going to vote out next week, some version. We will have something done by next week. But we are working on amendments.
It's not quantity, it's quality, Rep. Johnson.
But I also don't want people to just use delay tactics. This bill has been out for 3 weeks now, and I think it is a timely issue. But we are trying to address those concerns.
I look forward to that being addressed next week.
All right. Representative, thank you for those questions and comments. I will say that initially when we first started doing the bill, we were actually going to be much harsher on our House offices than we were on the Senate, and well, at least because we had more control. But there were groups that talked to us and were really concerned that we weren't giving some employees potential full benefits what they were deserving. So we were going to be much harsher on the House actually than we were on the administration. So.
All right. Well, I don't see any other questions here, so thank you for your testimony. I know we will continue to work, get those amendments, and then we'll try to get a substitute to you guys so we can be ready to vote on this next week. All right, we are now going to go back to the votes now that Rep. LeGrand is here. First off, we want to do House Bill 4257. This is the one regarding memorandums of understanding, ensuring that they are filed with the Office of the Great Seal. So with that, I will entertain a motion to report with recommendation House Bill 4257. Representative O'Malley so moves. Madam Clerk, can you take the vote?
On the motion to report House Bill 4257, Chair Johnson?
Yes.
Representatives Outman?
Yes.
Whitenga? Yes. Riley?
Yes.
O'Malley?
Yes.
Wozniak?
Yes.
Berksey?
4257?
Memorandum of Understanding Bill.
Yes.
LeGrand?
Yes.
Young?
Yes.
Mr. Chair, you have 9 yeas, no nays, and no pass, so that the bill is reported with recommendation.
All right, House Bill 4257 is reported. Moving on to House Bill 4448, we will now adopt the H1 sub to address the concerns of Rep. LeGrand. So with that, I will accept a motion to adopt the H1 sub for House Bill 4448. Rep. LeGrand so moves. Madam Clerk, please take the vote.
On the motion to adopt the H1, Chair Johnson?
Yes.
Representatives Outman?
Yes.
Foytinga?
Yes.
Riley?
Yes.
O'Malley?
Yes.
Wozniak?
Yes.
Birksey?
Yes.
LeGrand?
Yes.
Young?
Yes.
Mr. Chair, you have 9 yeas, no nays, and no pass, so that the H1 is adopted.
And with that, I will entertain a motion to report with recommendation House Bill 4448. Representative O'Malley so moves. Madam Clerk, please take the vote.
On the motion to report the bill as substituted, Chair Johnson?
Yes.
Representatives Outman?
Yes.
Foytinga?
Yes.
Riley?
Yes.
O'Malley?
Yes.
Wozniak?
Yes.
Birksey?
Yes.
LeGrand?
Yes.
Young?
Yes.
Mr. Chair, you have 9 yeas, no nays, no pass, so that the bill is reported with recommendation as substituted.
House Bill 4448 is reported. All right, with that, I move to the portion of the committee that makes me the most nervous, where I hand the gavel over to my vice chair here. So with that, the committee will go at ease. Call the chair.
All right, the committee will come to order. We will now take up House Resolution 60, which grants this committee the power to issue subpoenas and continue our investigation into the reasons behind non-disclosure agreements made between former DHHS Director Robert Gordon and the Governor's administration. Rep. Johnson, the floor is yours.
Well, thank you very much, Chair, for that. Happy to testify on House Resolution 60 today. Something that we are trying to avoid getting to this point. I think I put in front of you 4 different letters that we have sent to Director Gordon, inviting him to testify before this committee voluntarily, trying to avoid the subpoena as much as necessary. But at this point, he has refused, even though about a month ago, I believe, Director Gordon and Governor Whitmer actually amended their agreement to remove the confidentiality portion, so he could speak freely with us, yet he has refused to. To me, begging the question, what's the point of removing the confidentiality portion if you're still not going to talk? So this resolution authorizes the Oversight Committee to issue subpoenas regarding the severance agreements. Just to explain for the committee the process of this, ideally, I believe in passing this resolution out of this committee today, there would then be a record roll call vote on the House floor. If that would be passed, then the Oversight Committee would have to take a vote every time we issue a subpoena. So this is not the subpoena itself. This is not actually subpoena Director Gordon. That would be a further discussion at another point. This is just giving our committee the authority to do that. So basically, I think that where we are, it is our job as an oversight committee to provide oversight of state government. It's an important check that we provide on the executive branch. And when you see that type of agreement occur for the public health director during a public health pandemic to resign in a very strange way, where was he fired, was it voluntary, no one really knew. Then we see there's a confidentiality agreement. There's a lot of unknowns there. And so I think it's important for us to ask those questions, to get those questions answered, and that's the purpose of this, is about this committee doing our work. When it comes to the subpoena process, there's 2 main purposes. One is developing legislation, which we are in the process of that, right? With Rep. Ross Bell, we are working through that process of developing legislation regarding these NDAs. This is something that his testimony, I believe, could be valuable to that as we work through that process. And the other one, which is obviously much more paramount, is for an oversight perspective. And we are obviously the Oversight Committee. So if there's any committee that should be issuing a subpoena for this purpose, it would be our committee. With that, I am happy to answer any questions that the committee members may have.
Well, thank you for that, Rep. Johnson. I think this is an important step for our committee, and with that, we'll move on to questions. Rep. LeGrand.
So a number of you were here last session, and I actually gave sort of an extensive floor speech on this issue. And so I'm just going to touch on a couple of the concerns that I raised in that speech again to refresh everyone's memory and for the new members. So we had a very traumatic experience in our nation's history, which were the McCarthy hearings. And I think that one of the things we always have to be careful about in government is getting into a dynamic of witch hunts. And I'm not suggesting that we are gearing up for a witch hunt here. But what I am saying is I want to stay a long way away from witch hunt dynamics. As I think all of you know, I'm an attorney, and one of the standards that we have for in the legal field, and one of the points that I made in my floor speech was, I'm not sure that I want to start making this a making our committee and our parts of the government essentially a quasi-court, because I don't think we do a very good job of being a quasi-court. And having been through this oversight process last session, when Rudy Giuliani came into town, he essentially got to lead a witness down the garden path for 2 hours without any room for objection or any of the standard things that courts put in place for witness testimony, and it just sort of went off the rails. And so we had a lot of the worst characteristics of a trial, and combined with a lot of the worst characteristics of a standard hearing. And so my concern is if we start gearing this body up to be essentially a quasi-court, courts have court rules. They have procedures. They also have people who have been to law school who have been trained to do those kinds of things, and who to play within sort of the rules of the road. If we start issuing subpoenas, I think we're making a procedural shift that I'm not willing to do yet. And I say this with a lot of respect for my colleague, the chair. And I understand, and I honestly, frankly, think reasonable minds can differ on this. And I understand where he's going, and I understand how he's going to vote on his own resolution. I just want to make clear what my arguments are on the other side of this issue, because I want to have a good discussion of this. So in a court, you can't just drop subpoenas on anybody and just call any witnesses you want. You have to have a threshold inquiry. You have to have essentially an articulable reason. So to cut through all of the smoke around Gordon's resignation, if I had to guess, if I was sitting in a bar with a beer and you asked me what I thought happened there, without knowing anything, I might guess in a bar with a beer, probably Governor Whitmer got into a massive disagreement with her director about shutdowns or pauses or restrictions, and he said, I disagree with you. And she said, okay, well, then it's time for us to part paths, which is essentially, it seems to me like in careful language, he said in his letter to us. Now, if that's what happens, that happens with employees every day. Like if I have a server at my bar who isn't willing to do what I ask them to do, well, then we're kind of done, right? They work for me, and if they're not willing to do what I want them to do, they can disagree with me about how we ought to serve tables, but at the end of the day, I get to fire them. If there was any threshold indication here that he was fired because he was, for sexual impropriety, or because he embezzled, or because he was, going out on the weekends and getting in bar fights, or whatever, then maybe we'd have a reason to need to subpoena him to understand the circumstances of his termination. What I don't want to get into is tabloid journalism by way of committee, and I don't want to get into essentially a disagreement between those two and putting somebody under oath and then having him have to swear to probably an awkward, heated conversation that happened between two people. I mean, if I'm going to fire somebody at my bar, they may tell me I'm ugly and my mother dresses me funny. They may say nasty things about me while I'm firing them. I'm not sure that we really dignify the process of government by getting into the weeds on something that was probably an angry event that happened on a real serious disagreement about policy, and I have no reason to think it was about anything that would cause us alarm. So given that, respectfully, I'm not sure that I want to give this, I don't on balance think, I'm still open to having the discussion and listening to my colleagues, but I'm inclined at the outset here to not want to give this tool to this body, and to hark back to what I said a couple minutes ago on another issue, and what I said in my speech on the floor last session. It's really important to me that that civility always comes before coercion. And that being said, Chair, you've clearly tried civility here. So I want to give you credit for that. You know, saying we need to subpoena him because we need to subpoena him without asking him to come in would be coercion before civility. So I appreciate your attempts at civility before coercion. However, in this case, I don't think coercion is warranted, to put it in, I hope, a little plainer English than legalese. So given that I really, really want our government to work by civility, and I don't want the executive branch needlessly at war with the executive branch or the judicial branch, there are times and places when we're going to have real conflicts. But internal hiring and firing discussions in the office of another branch of government, I mean, I'm not sure that I would want the governor to be able to open an investigation about me firing my LD and bringing my legislative director in to ask under what circumstances did your boss let you go. Because frankly, I wouldn't want to have to do that to him because Phil will not answer his phone. And his voicemail is always full, and it drives me nuts. And I've yelled at him about it a number of times, and he keeps doing it. But I'm not sure that I'd want that to be. I'm not sure I'd want the governor to be able to subpoena me to ask me why I fired my LD if tomorrow I fire Phil because I'm sick of him having his voicemail full. So thank you, Mr. Chair.
All right, so a lot of points there to address, and a lot of them I think there are legitimate concerns. First off, I think comparing what we're doing here to last term, I think that's an unfair comparison. I have a tremendous amount of respect for the former chairman, but we do operate differently. I think an elections issue is far different than this issue, so I would point out that. Second off, and you alluded to this, we tried to go down the voluntary route, right? We've issued multiple letters. I mean, we could have done this a month ago, but we have waited as long as I think reasonably possible. Furthermore, this is just giving us that authority. We still would have to vote each time we decide to do a subpoena, so we can, and my guess is we're going to have this same discussion when that happens down the road. So we get another vote on that point. And then I think the final point that I'll make here is when you say, do you really want us being involved for every time someone gets fired, terminated? We were not looking at doing a subpoena when he left initially, right? There's a lot of questions. We were asking that, but no one ever even really thought of saying, hey, we're going to subpoena him in. The issue was when it was reported that he received $155,000 to stay quiet. That's when it's like, wait a minute. It was kind of sketchy how you left, and we had questions, but we weren't subpoenaing you at. But now we're being told you get a large sum of money to walk out the door and not to say anything. And we're talking, and I know this is, the resolution here is broader, but we're talking about Director Gordon here. This is someone who takes an oath of office. This is not some low-level employee. This is, you know, a top director in the state of Michigan. Once we find out that there is an agreement to stay quiet for a large sum of money, then I think the legislature has some role there. And as much as we were happy to see that they removed that confidentiality portion, and I thought that was sort of the opening steps to him voluntarily coming here to speak with us, yet still refusing to do so, to me, there's a lot of questions that have to be answered. I would love for it to be done voluntarily, but that's not happening. We do owe the people in Michigan proper oversight of state government, and I believe in this instance, for us not to pursue this investigation, to not get these questions answered, I think would be a dereliction of our duty here, and I think it would actually lose trust in government for most people in Michigan. But I understand your concerns.
Likewise, Mr. Chair, I mean, I think this is a close call because there's an issue of transparency here. So I think all of your points are absolutely well taken, and so I'm glad we're having this discussion.
Absolutely, and thank you for your question, Rep. LeGrand. I mean, I think all the members on this committee echo those concerns. We don't want to go on witch hunts. We want to use it sparingly, but do our due diligence when we need to, and I think this is a unique opportunity where we need to do that due diligence. So moving on to Representative O'Malley.
Thank you, Mr. Chair. Thank you for your testimony. Couple of questions. You would agree that this pandemic is a once-in-a-lifetime event, right?
Yes.
Yeah, we hope. And so this is a very visual, very high-profile event, and there has been lots of discussion about what has happened, what hasn't happened, why things have happened, and for the most part, would you agree that we feel that there's not been a lot of information coming out of the governor's office explaining why things were done?
Correct.
Okay. So then it might be very informative as to know what it was they were disagreeing about, because maybe there were some issues that we should know about.
I think that stands to reason that we would like to know what were the areas of contention between the governor and the director.
Okay. The power for the legislature to offer subpoenas is part of the Michigan Constitution, right?
Correct.
Why would the people at that convention, constitutional convention give us that power if it's not really wise for us to use it, because we're not a court system? Why do we have the power to subpoena?
I think that's a good question. I mean, you can make the argument that we should use it sparingly, but to say that we should never use it would not pass any constitutional muster, because we were given that authority for a reason.
Yeah, they must have had something in mind when they gave us that power.
And I believe a once-in-a-lifetime pandemic in a situation like this could be that time.
I would agree with you. Thank you, sir.
Thank you.
Thank you, Mr. Chair.
Representative Wozniak.
Thank you, Mr. Chair. Rep. Johnson, I really like your bill or the resolution coming forward. I see the discussion is going to be limited to employee separation and severance agreements. Is that correct?
That is correct. When we do a resolution for subpoena power, we can't just give us, carte blanche, subpoena, whatever. It has to be to a specific cause.
Right. And are there any ground rules that are different for self-incrimination for the witness?
That is a good lawyer question. I am not a lawyer. You are. That's a good question.
Well, yeah, it's new territory here.
Yes.
So.
I don't know the answer to that. I'm sure we could try to figure that out. I don't know if our legal team wants to maybe chime in at some point
Maybe
and see if
look
we
at
can
it.
find it. Yep.
All right. Thank you.
Representative Brixey.
Thank you, Mr. Chair. Representative Johnson, I enjoy it when you surrender the gavel and come before us. It's fun. I have a couple questions for you. The first question that I have for you is what evidence, what is the basis for subpoenaing Director Gordon?
I think it's important to note that that is not what this is here. This is giving us the authority, if we wanted to do that. That would be, in my mind, that's something that will happen down the road. But I'm still happy to answer your question. I want to make sure we're clarified. This does not subpoena Director Gordon.
I understand
This just
that.
gives the committee the process. To answer that question, I think the main issue here is you're talking about the top state public health director resigning in the middle of a health pandemic under questionable circumstances, and then when we find out later a $155,000 settlement to stay quiet, then that confidentiality portion is removed, yet still refuses to talk to us after multiple attempts. I think that is a good reason for a subpoena to say, hey, we want to know what exactly was the reason for the termination there.
But what evidence do you have of wrongdoing?
Have I suggested wrongdoing?
If you don't have any suggestion of wrongdoing, any evidence of wrongdoing, it seems inappropriate for us to launch an investigation. So another question I have is...
I guess I would disagree. The point of the Oversight Committee is to provide proper oversight of state government. You don't wait until you know that something is wrong to do oversight. You continually do oversight to make sure that you're keeping the executive branch in check. That's the purpose of checks and balances.
So what circumstances were questionable?
For me, when I see the $155,000 payment to stay quiet, right? We did not issue subpoena. We did not go down this road. When he left, there's a lot of questions. I had a lot of people in the media asking me about it, and I was like, look, I don't know what's going on. But we never said, let's subpoena. We just had questions. But then when you see that there's an agreement for a lot of money to stay quiet, that's when all of a sudden a lot of red flags are going up. And there's a reason that the governor has changed her policies on this. There's a reason why we're doing legislation on this. It's because the vast majority of our citizens that they have entrusted us with running government here, they have a big issue with this. They're saying this doesn't make any sense. Why is our taxpayer dollars being sent to keep someone who is a top health director quiet? And those are questions I'd like to have answered.
But now they're not quiet, and he's not bound to any kind of confidentiality. So, the resolution itself suggests some kind of wrongdoing, and there isn't any evidence of that. Did you inquire with the Office of Auditor General to see if there was any auditing that was conducted in this matter?
The Auditor General does a very thorough investigation, right? So we just found out about this, I believe, in March. So they would not have had time to do a full investigation. Now, Rep. O'Malley on the committee here has done great work asking them for that full investigation. But that takes time. Because they do such great work, it's very thorough. It's very, it's time-consuming. I believe an issue like this, as a legislative body, time is of the importance, and to have some questions answered from the director, I think makes a lot of sense.
But we aren't.
So let's just go right to the top and have them answer those questions.
But we aren't investigators, and the Auditor General does have that ability, and we don't do that. That isn't really in our purview. So I have another question.
I believe the Oversight Committee is charged with investigating. When there's an issue, that is our job.
Okay, so can we add the legislative offices to the resolution so that we can look into all of those $632,000 of Senate agreements that...
Well, from a legal perspective, that doesn't make any sense to give the legislature authority to look at their own records. We already have the authority to do that.
To subpoena them. If we want to subpoena somebody about the oversight of the Senate agreements or the House agreements, then we should put that in there, because this is the first step to doing the subpoena. You can't do the subpoena without this step.
Right, we can't subpoena records until we do this. And we could already look at a lot of our own records. We could already, if you want to have conversation with the House Business Office, with General Counsel, you're more than welcome to already do that as a legislator. I think from a legal perspective, it really wouldn't make any sense to give the legislature power to investigate themselves. We already can do that.
And I'm suggesting that if you are taking objection to a separation agreement, that we should look at our own too. And did you ask the Auditor General? Did you ask the Auditor General if there was an audit? Shouldn't we ask that question?
Once again, Representative O'Malley is in talks with the Auditor General on this issue.
Representative O'Malley said he wanted a list of all of the audits that were done. I'm asking you, as the writer of this resolution, did you contact the Auditor General before thinking that this committee should take on oversight? And this gets to the question of, is there any evidence of wrongdoing, which you have not provided a single shred of evidence. So did you contact the Auditor General, and will you contact the Auditor General? Because it sounds like you haven't.
All right, a couple points. I feel like I've already addressed this. This came out in March. The Auditor General does very thorough investigations. They're not ones that just jump on something very quickly. So it would not have made sense for them to have an investigation done on the audit already. So no, I did not ask them because that would not make any sense. Have I asked them? Am I going to ask them? No, because Representative O'Malley is already going down that path. It doesn't make sense for both of us to ask the exact same question. As far as to providing a shred of evidence of wrongdoing, what I am suggesting is getting a $155,000 payment to keep quiet as to why you parted ways as the top health director during a health pandemic. I think there are a lot of questions there. We don't need proof of wrongdoing. This is not a court. We're not criminalizing anyone. We are asking questions. That is the purpose of oversight. We ask a lot of questions. I think we have a lot of committee members here that ask a lot of very good questions on both sides of the aisle. That is our role here, and that's what we are going to continue to do. And that is the purpose of this, is to make sure that we can have the proper individuals and documents before us so we can ask the right questions to find out exactly what happened so the people in Michigan can have some trust in their government to make sure there's not these shady deals going on.
Okay, so then in order for it not to look like a partisan witch hunt, I hate to use those words because they've been used recently in a pretty poor manner, I would request that you include language for us to also investigate our own separation agreements and give the ability for us to take testimony on the House separation agreements and the Senate separation agreements, because they included even larger amounts of money, which if we're doing oversight, and we're doing oversight of HR issues, we ought to be looking at every single separation and asking these questions and treat people fairly.
Once again, I will say it would make no legal sense for the legislature to pass a resolution giving them authority to investigate themselves. We already have that authority. But aside from that issue, if you will notice, I have not talked about I think it was a Deputy Director Esty. I've talked about the top individual, Director Gordon. This is someone who takes an oath of office. This is far different than an IT employee. Now, do IT employees get severance agreements with confidentiality requirements in there? Yes, because a lot of times they're saying proprietary information in that IT code. That is far different than the public health director during a public health emergency resigning under just out of nowhere. So I think to try to conflate the two actually makes no sense. Now, if you don't want to be political, vote yes. It doesn't have to be political. I believe if you guys want to come on board and vote yes, then good. It's more transparency.
We got to move on. We're just kind of doing circles here. Representative O'Malley, would you care to respond?
Yeah, I'm just going to throw out a couple things. One, what I've asked the Auditor General to do, and no one had asked prior, is to go and look at separation agreements and payments above $50,000 over their history. So looking at all administrations, so we have a feel for what maybe has been done. And I guess one of the questions that I'd ask now, listening to that discussion, is, to the best of my knowledge, and I'll see if you agree, we can argue that a severance package was too broad, too expensive, which maybe is more the case in the Senate. To the best of my knowledge, and I ask you, sir, the Senate issue, I don't believe there were any non-disclosures involved there, and I think that's what raises the smell test on this, is a payment and the non-disclosure.
Right. It's not just the amount of money, even though I think that's questionable when you're reaching $155,000. It's also you now must stay quiet, especially, in my opinion, the top health director during a health emergency. Why would you want him to stay quiet? He must have information that would probably be valuable to a lot of other people around the country, being in such a high-profile position, yet you're requesting silence out of him. That's what doesn't add up to me.
Yeah, it's not about having your cell phone messages full.
Right. Thank you.
And thank you for that clarification, Rep. O'Malley. Any other questions for Representative Johnson here? Okay, well, thank you for your testimony, Rep. Johnson. This resolution is an important step towards getting the answers the people of Michigan deserve, and with that, the committee will go at ease.
The House Oversight Committee will come back to order. All right, seeing no other testimony on this resolution, I will entertain a motion to report House Resolution 60 with recommendation. Representative Riley so moves. Madam Clerk, please take the vote.
On the motion to report the resolution, Chair Johnson?
Yes.
Representatives Outman?
Yes.
Poitinga?
Yes.
Riley?
Yes.
O'Malley?
Yes.
Wozniak?
Yes.
Berksey?
No.
LeGrand?
Pass.
Young? No. Mr. Chair, you have 6 yeas, 2 nays, and 1 pass, but that resolution is reported with recommendation.
House Resolution 60 is reported. For a second there, I thought it was going to be bipartisan. All right, moving on to maybe a little less controversial issue. Rep. Young has House Bill 4617, and if you wish to come testify, we'd love to have that. Which I will note, as all the claims of partisanship, I adopted a Democrat sub to a bill. We have another Democrat bill before us. You know, Representative Matt Hall always claims to be the most bipartisan chair out there, but I think we got some competition here.
Well, greetings, Mr. Chair and members of the Oversight Committee. Thank you all so much for the opportunity to testify on my bill, House Bill 4617. I think I'm far enough away from everybody. Okay. House Bill 4617, which is now tie-bar to House Bill 4383. And it was during my review of House Bill 4383 and the testimony of the bill's sponsor that I began to really question why incarcerated persons were exempt from the definition of persons, people and entities allowed to access FOIA, FOIAble information, and asking questions. I was told that these concerns kind of stem from incarcerated persons having the ability to spend all day FOIAing information. And so I said, okay, I get that, but what if we place some limits on their ability to FOIA that information? And then the response was, well, we pretty much just decided to leave it as it was and not change anything. And so I thought, the thing that we do as legislators and lawmakers is amend bills and legislation. We try to make it better. We don't just leave things at the status quo. So I began to do my research and found that with our 50 states that there are probably 9 that have restrictions. And of those 9, like most of them aren't as strict as Michigan is. And so they allow incarcerated persons, the majority of our states allow incarcerated persons to utilize FOIA. And believe it or not, even when talking to criminal justice reform advocates, some of them were even shocked that Michigan exempted incarcerated persons. And so that's why I'm here today. Our current prohibition, to me, kind of feels like dehumanization of the incarcerated. When you tell them that you don't fit in the definition of a person, that's dehumanizing to me. And so we look at them, and they exist in a cell with a bed and an uncovered toilet just inches away from one another. What I'm asking is that we give them the dignity of being included in the definition of persons and allow them the access to information pertaining to them and them only, their personal information regarding their case and potentially their children that they still have a legal right to. God forbid any one of us or someone that we love ends up behind bars and lose our personhood. And so thank you, Mr. Chair, for entertaining this legislation and allowing me to have a hearing on it. And thank you to my colleagues for your attention. As I said during my first comments in this committee, everything I do is driven on the love and care that I have for people. And that's what this legislation is at the heart of as well. So with that, thank you. Any questions?
Well, thank you for your testimony. And you referenced the bill as tie-bar to. That's the Legislative Open Records Act that we passed, the expansion of FOIA to both the legislature and the governor's office. And I know you brought this question up in that committee, and I'm happy to see you're following through on that. I believe Representative O'Malley has a question.
I do, and a quick comment. Again, so right now, if I'm incarcerated, I can't FOIA information that could potentially help me with my case, or as you mentioned, with family, if there's an issue outside that has nothing to do with my case, but my family has a problem, I can't get information.
That's correct. You cannot, not in the state of Michigan.
I agree with you. That doesn't seem right. And my comment is, Representative, this is the first time I've seen you without your mask. And it's a beautiful smile.
Thank you, Representative O'Malley.
You are welcome.
I don't sell Representative Hoytinga.
Like you, I was a little shocked when I heard testimony, and that was the first time I had heard about this too. And so I'm glad that you're pursuing this, and I would support this, you know, with some reasonable limits if you guys go further with this rather than just a definition and go further. So thank you for bringing this forward.
Thank you.
Representative Brixey.
I just want to thank my colleague from Detroit for being so thorough and doing your job as a representative in such a thorough manner and catching this, because I missed it. All of us missed it. And as soon as you asked the question, you know, we all started thinking about it. So thank you so much for being such a good representative to bring this forward so that we can right this wrong and give people the ability to seek justice.
Thank you.
And I believe we have someone on Zoom as well. I don't know if you want to sit down or stay up there for his
I'll
testimony.
stay.
But Daryl, are you on Zoom?
Mr. Siggers, Daryl Siggers?
I think you might be muted. All right.
Can you hear me?
Oh,
Yeah,
there
we
he
can hear
is.
you.
Okay.
Yes. My name is Daryl Stiggers, and first let me say thank you to the chair and the members of the committee. Thank you also, Representative Young, for bringing this important legislation. I served 34 years in prison for a crime I didn't commit. I was arrested in 1984. I was released in 2018 after being exonerated by the Wayne County Conviction Integrity Unit. While in prison, one of the hurdles that I faced consistently was the ability to access FOIA, particularly in my later years when I began to understand the importance of documentation to support any type of litigation or allegation of police misconduct in my case. And so I began to develop and establish a company, even then, while I was in prison, called Legal Access Plus. And what Legal Access Plus does is we FOIA information, the prosecutor's file, police file, and court records on behalf of prisoners. And so, again, when I was inside in the later years, I didn't have access to that information. And so at some point, I filed a Freedom of Information Act through a family member, and I was able to obtain some just vital information concerning my case. And so right now, inmates from all prisons contact me, and they pay me to file FOIA on their behalf. And so first, let me just say, if this bill is passed, and I pray that it is, because I think it's worthy and it's necessary, it would essentially put me out of business. But for the greater good, I would be willing to sacrifice that because it is a vital tool that is necessary for inmates. Because I get inmates their files, and they find information in there with regard to police misconduct, prosecutor misconduct, and other things. And without this information, they can't properly litigate their conviction. So here I am, innocent, in prison 34 years, and not able to get copies of my prosecutor's file and police file. And upon obtaining these files through other individuals, and it took a task to do that because family members don't have time, they don't know the process, they don't want to do it. And it just makes sense to allow prisoners to do it themselves, because as I said, a lot of information is in these files that they don't have access to. Sometimes police officers withhold information, sometimes prosecutors withhold information. And when you get these files, you will find some of them, they find a treasure trove of information that they can use to prove their innocence. And no greater crime can be committed than to incarcerate someone for a crime they didn't commit and then prevent them from getting documents. Now, I understand there's the concern that inmates in the past, they abused the process, that's why they were exempted. Well, this bill narrowly focuses on information that specifically concerns the inmate and anything regarding his, maybe his parental rights or his child. So I think it's reasonable, and I just hope this committee will grant this bill or approve this bill and make it into law, because I think it's necessary. Thank you very much.
Thank you for your testimony, sir. If I may ask, how long were you wrongfully convicted for? How long were you incarcerated?
34 years.
Wow. And what was it that eventually overturned your conviction to get you out?
Ballistic identification. We found out that the so-called expert, Detroit Police Department expert, wasn't an expert at all. He had lied and said he had been with the Detroit Crime Lab for 6 years. He said that it took him, you had to be under the apprenticeship for 2 years. We found out that he hadn't, when he did the test in my case, he had only been in the Detroit Crime Lab for 364 days. And I got this via FOIA. This is how we found this out. This guy wasn't an expert. He wasn't even qualified. This guy had all type of criminal stuff in his background. and was still allowed, he withheld this stuff from the prosecutor's office. And we found this out through the FOIA process, which ultimately, along with some other things that were uncovered through the Wayne County Conviction Integrity Unit's investigators concerning witnesses and other police misconduct. But the point is, one of the vital documents that led to my exoneration was obtained through the Freedom of Information Act.
Good. Thank you for sharing that with us. I don't see any questions for you, so thank you for being here this morning for that. Thank you for your testimony. Do have a couple cards to read in that are in support of the bill. They have provided written testimony that will be available to the committee members. Kenneth Nixon, as well as Wolfgang Mueller with the Mueller Law Firm. Both of them are in support of the bill, not wishing to speak, but have provided written testimony. Committee members, I would be prepared to vote on this next week, perhaps, so if you have amendments or changes, please get that to us as soon as possible. All right, we are going to move on to the next bill, which is one of mine again. So with that, the committee will go at ease, call the chair.
All right, musical chairs. The committee will now come to order. So the final item before the committee today is House Bill 4041. This bill would allow Michigan residents a first shot at reserving state campgrounds before reservations are opened up to non-residents. Michigan taxpayers pay to maintain these sites, and they should have the first opportunity to reserve their spot. So, Rep. Johnson, would you like to speak on this bill?
Absolutely. Thank you for giving me the opportunity to testify this morning on House Bill 4041. This is truly a bipartisan bill. I've got both Republicans and Democrat co-sponsors on here. It's really not the best day to talk about camping. You know, the weather was just fantastic earlier, and now today it got cold again. But everyone's looking forward to getting out, enjoying the wonderful things that Michigan has to offer. We have some of the greatest state parks out there. I know in my neck of woods, I've got Gun Lake, and then you got Holland, Grand Haven, Muskegon, Pentwater. You know, west side, best side. We got so many good things going on the west side of the state there. And what you'll see during the peak camping season is those spots fill up so quickly. I think it's about 6 months prior you can reserve, and it's literally within minutes those campsites are taken, which is good. I mean, that's a good problem to have. That means we've got a good product there. But then this was brought to me by a constituent of mine. He said, you know, we went there, we can't get campsites most of the time, but sometimes we'll still drive through and we see the vast majority of the license plates aren't from Michigan. He said, this is state property. This is public land that belongs to the people of Michigan. And he's like, I'm not opposed to people from Ohio coming up and spending their money here, but man, this property belongs to us, and yet they're kind of getting in front of us here. Is there a way to try to help us get a jump on that? And so that's what this legislation does, is it basically opens those reservations for state parks, state forest campsites about 2 weeks ahead of time for Michigan residents, and then after that it's open up to everyone. So you're not going to have, you know, campsites left open because of this. It's just giving a head start to the people of Michigan. It belongs to them. That's what state land means. It means it belongs to the people of the state of Michigan, and I believe they should have that first opportunity to use it. So with that, I'm going to open up to any questions you guys might have.
Representative Young, I believe you have a question.
Hello, Representative. So in Detroit, Belle Isle Park is now a state park. But we don't necessarily do camping at Belle Isle. But what we do, we rent shelters for picnics, for family reunions, for all those types of things. And so many times you're hard pressed to get a shelter reservation at Belle Isle. So now my question is, perhaps we can add an amendment where it's not just campgrounds, but even shelter reservations for folks that, like us in Detroit, are trying to get access. And then now that it's a state park, people from all over, like you said, will come in and have an opportunity to rent these shelters, and now we can't have our family reunions and whatnot. So just listening to you, I'm like, yeah, I kind of like this idea, Representative, but could we include shelters?
Yeah, so I'm reading the definition right now. It says campground, cabin, yurt, or lodge. I don't see any reason why we can't put shelter in there as well. That makes sense to me. Yeah, happy to work with you on that amendment. It's a good idea.
Yeah, fantastic. Great idea. great idea, Representative Young. Any other questions for Rep. Johnson here? Okay, seeing none, thank you for your testimony, and the committee will go at ease.
The House Committee, or the Committee on Oversight, will come back to order. First off, I have a card to read in support of the bill. Not wishing to speak is Bill Sheffer with the Michigan Association of Recreational Vehicles and Campgrounds. Next up on Zoom, I believe, is the DNR Legislative Liaison, Craig Brunette, does wish to speak and is opposed to the bill. Craig, are you on Zoom?
I am. Can you hear me, Mr. Chair?
Yep, we can hear you.
All right. Thank you, Mr. Chair. Again, my name is Craig Burnett. I'm the Legislative Liaison for the Department of Natural Resources. Also with me on Zoom is Ron Olson, the Chief of our Parks and Recreation Division, and Jason Fleming, who is the Section Chief of Park and Recreation Division, Resource Management Section. As you explained, Mr. Chair, the House Bill 4041 would prohibit non-residents from making a camping reservation until residents were first given a 2-week priority. That would be, if this were to become law, that would be the first time in the over a 100-year history of our state parks that such a rule would be in place. Currently, when we look at reservations, only about 89% of all of the early reservations are, about 89% of early reservations are made by residents. Only about 11% are made by non-residents. And then another point is that non-residents will be paying all the associated fees. They'll be paying a non-resident state recreation passport as well when they come into our campgrounds. And then on top of that, these out-of-state tourists, these non-residents, when they come in, they bring needed tourism dollars to the state and local economy. So we're a little concerned with the message we're sending. So because of all those reasons, the administration is opposed to this bill. Again, happy to take any questions. And again, Ron and Jason are available to answer any questions about the current process or more specific questions to our parks.
No, thank you for your testimony on this. I guess my first question, when you talk about, the out-of-state people bring their tourism dollars, obviously we support that. My question is, what does the DNR believe the primary purpose of state land is?
All state lands were there to provide access, and we hold those lands in public trust, and we're there to protect them for future generations and utilization for current generation.
So it's not for tourism dollars?
It's for enjoyment of all those that live here and those that want to come in and visit our state.
Right, I would agree. I think primarily, though, you would agree that when it's state land, that's owned by the people of Michigan, right?
I would agree.
Okay, so the people of Michigan own it. Would it make sense that if you own something, you should have first right of refusal over someone who doesn't?
Well, what I would say is that first, it's important to know most of our majority of our state parks are funded through camping site fees, and those fees are paid the same by either resident or non-resident. Very little general fund tax dollars go into our state park system. That's something that Chief Olson or Jason could probably comment on a little bit better than I.
Right, I didn't ask about the funding of it. I said, who owns state land? Would you argue it's the people of Michigan, right?
That's what I said, Mr. Chair.
Right, so I guess my follow-up question to that was, shouldn't the person who owns the land, hence here the people of Michigan, have that first primary responsibility or ability to use it over someone who doesn't, such as someone from Ohio?
I would say we're just trying to make sure that our parks are utilized and that we have access and it is equitable to all those that want to utilize the parks. We would not feel that agree with the message that we want to send out is that those wanting to come and bring their recreate and visit our state don't have the same equity to those sites.
Well, we can certainly work on messaging if that's the issue. They are being used. I'm an outdoorsman. I like to go out and about. I see a lot of these places. I assure you, in the summertime, they're packed, and that's a good thing. You talked about how 89% of early reservations are Michigan residents. I think it actually makes sense. The question is, in the peak season, how many of those are Michigan residents? Because When it's non-peak season, you tend not to travel as far. And so that's going to obviously be a lot more Michiganders. But when you're talking, July and August, that's the times when it becomes very difficult to get that campsite. And when you go through those state parks, that's when you're seeing a lot of trailers from out of the state. Now, we're glad that they're coming here. We're glad they're spending money here. But if it's at the expense of the people who truly own the property, then I think there's a problem there. So do you have any data on how many early reservations are by Michigan residents during peak season?
Greg, I don't know if you can hear me or not. My camera isn't working, so.
We can hear you.
Okay, thank you, and I appreciate that. Sorry, my state computer's camera is not working very well, so I need to get a new tablet. This is Jason Fleming, and I appreciate the opportunity to communicate with you some of our concerns on this. So when you asked the question about 89%, that is when we look out 181 days in advance of arrival, depending on the locations that you're at, it's going to vary a little bit. So for instance, we'll use Yankee Springs, for instance. 181 days out, less than 4% of those that are making a reservation are coming from out of the state, whereas maybe Grand Haven, it's about 12.8%. So that number doesn't change significantly from when the reservation's made to when it's actually utilized. Yes, there are times seasonality will change as far as how campgrounds are used, but when we're talking about our peak times, which is I think the biggest concern that I'm hearing, is that wanting to have people to access to those times during July and August, those numbers that are around 89% apply statewide. Again, there are places that are near the border that also have significantly higher numbers of out-of-state residents, such as Warren Dunes, Sterling State Park. But there are also those that for most of the larger parts, we're seeing anywhere from between 4 to 12%, 13% on average.
Yeah, I can just speak from personal experience. Yankee Springs is right near where I live, and so what I like to do 4th of July weekend, you do your parades in the morning, and then I like to go for a bike ride, kind of relax in the afternoon. We like to ride our bikes over there and just kind of look at the license plates. And usually, from personal experience, there's not a lot of Michigan license plates. There's a lot of out-of-state people. And usually we try to count how many states are here. The place is packed. In our experience on those really high-profile weekends, you're seeing a lot of out-of-state people. Representative LeGrand, I believe, has a question.
So, Mr. Chair, you're a flexible thinker, and I appreciate that about you. I would say that as written, I was going to be quiet, but we got into enough detail here that I'm going to stop being quiet. I like to think of myself, because my personal values, I happen to be a Christian, and so because I'm a Christian, I tend to think that I'm really a citizen of the world, and I'm only contingently a citizen of the United States. I have to care about people in Kenya, and I have to care about people in Afghanistan, and I have to care about people all around the world. But putting that to the side, I really do like the United States as a unified group, and I'm not a huge fan of differentiating between, and look, I know we fought a war with Ohio, but that's in the past. And I know people like to hate Ohio football teams, but at the end of the day, people from Ohio are in fact citizens of the United States. And I like a unified country. And so I'm often frustrated when we get what I think of as almost xenophobic bills that say things like, let's keep Michigan jobs for Michigan residents. Well, we've got a national labor market. People can move to Michigan. And I guess that's one of my first points here is you started saying, well, Michigan people own this land. Well, what do I have to do? What do I have to do to be a citizen of Michigan? I'm not sure I am a citizen of Michigan. I'm a resident of Michigan. If I moved to Ohio tomorrow afternoon, I'd be a resident of Ohio. Does that somehow magically give me ownership of the state of Ohio? Right? I mean, to say own about state property and then use it for people who are residents of a state is a pretty mushy transfer of concepts, given that, I didn't invest in it. It's not like we have 3 generations worth of residency requirement before you have ownership stake in Michigan. We're not a, commune with shares. So I think talking about Michigan residents owning Michigan land is frankly a little problematic logically and legally anyway. Now, having said all that, I think there are 2 other solutions here which I think might be better. Now, one I think is not better, but is logical and is free market and jumped out at me as if I put my libertarian slash free market lenses on, and that would be if you got a supply demand problem and things fill up in 10 minutes, well, then you can change your rules of supply. You could jack up the rates for reserving parks so that they didn't fill up in 10 minutes. So that if your problem is Michigan people are getting beat to the punch by people from Ohio, well, then you could do what California does, what San Francisco does on parking meters. You just jack the rates up to the point that there's an open meter on every block, which is a useful thing to do, right? And it's a way to use the free market. Problem with that, and we all heard it, we can all see immediately the problem there is we're letting rich people get spots in our state parks before poor people. So I don't think that's the solution here. What I would suggest you consider, and I'd love it if you'd consider a middle ground, which would be a quota. What if you took the parks and you said half of them we're going to reserve for X amount of time for in-state people, and the other half are first come, first serve. So you didn't say, because I think potentially your approach is going to say, if you live in Ohio, too bad for you, you're never going to get into our popular state parks because they're all going to be used by Michigan residents. And I do think there's a value to being nice to people in Ohio so we don't go to war with them in the future. I think that, if we start blocking our state parks to them, then maybe we're getting into we're going to incite some kind of state park war, and I could see it happening where Arizona's like, well, we're sick of people walking around our national monuments, and we got the Grand Canyon and you don't, so people from Michigan can't come to the Grand Canyon because you're not letting us come to Grand Haven. And I'd like to go to Grand Canyon. I haven't been there yet, and it's on my bucket list, so I'd really like to go, and I'd really like to go see some cliff dwellings. There's lots of things I'd like to see in other states, and I haven't gotten around to buying the RV to go do it, but I wouldn't like to get into essentially a trade war over state parks. So I think a middle ground might be to split them down the middle and do a bifurcated process, which would honor our duty to be nice to our own citizens without starting a war with the rest of the country over state parks.
Yeah, no, I hear your points. I think a couple key clarifications. Grand Canyon is a national park, so
I know.
It's different. And that's where Michigan, we have national park, where you got Pictured Rocks, which have been there, it's national. I do believe when you're talking state land, that belongs to the people of Michigan. That is, we have a budget item that goes to that every year. I think that they should get that first step because your taxpayer dollars, I know they're going to say it's mostly funded through campground fees, but there are taxpayer dollars that actually go to that. And in my mind, when it's state land, that belongs to the state, and that means the people of the state of Michigan. So we'll disagree on that one. Representative O'Malley.
Real quick, if I heard you folks right, 89% of the reservations are Michigan residents. Was that correct?
89% of the people who are reserving state parks consistently in the last several years are having a Michigan address, correct?
Very good. And it's my knowledge of our state parks, especially for camping, if there is, well, let me ask it, how much drive-up day of do you have a spot open, can I get in here, do you get?
So that'll depend on the location, of course. Statistically, we do have, when it comes to making reservations, there's a misnomer that you have to be in 6 months in advance. Yes, there are some high demand places and some demand certain times of the year. Coast Guard Festival at Grand Haven, for example. It's clearly, it's a day we might get 200,000 instances, communications trying to make a reservation for a very small number of sites for a small period of time. But we also have recognized that there is another third, approximately a third, and it varies from year to year. We're seeing it a little bit different in the last 2 years, some of it relative to the pandemic, but there generally is a significant number of reservations that are made within 30 days of arrival. That's about 43% last year. Within 7 days of arrival, 20% almost of our total reservations were made. Within 3 days of arrival, 12%. So there is some, talk about communication. One of the things that we try to communicate is that you don't have to be 6 months out to make a reservation. You may, in some locations, have high demand. In some sites, in some parks, for certain times of the year, it is competitive. But for the majority of it, people are getting into our parks and they're accessing it. But I just wanted to kind of answer that. There are, all the way up to the day of arrival, we had about 3% of our total. 3.5% was on our day of arrival.
Thank you very much.
Welcome.
Rep. Brixey.
Thank you, Mr. Chair. I have a question for either Mr. Fleming or Burnett. Do you have any idea of how much revenue how much money our state receives from out-of-state tourism in each year?
Yeah, we have and Ron might be able to answer this a little bit better. I'm not trying to put Ron on the spot, but we did have in our, there is a sizable amount of, what we've tracked in the past is what the monies that campaigns such as Pure Michigan have put out there, and they look, and Pure Michigan does a good job of estimating what those dollars are. It's a little difficult from our standpoint because we're just one piece of that pie, that larger tourism. We're a big piece, but not the only piece. There's lots of private businesses, private campgrounds that all have similar types of things. But we could probably take a look at the information that we have, and it would take some time to pull together what are those 11% that we're talking about, how much they invest in the system, because our reservation system is also a point of sale. So you can buy firewood and ice and other things through there. Outside of that, it would be difficult to ascertain how much is spent. Ron, I don't know if you've got something you wanted to add to that.
Well, we do have numbers that we've done on certain parks of what people spend and that kind of stuff. But and we do work collaboratively with Pure Michigan associated with tourism. We do keep track, and we do know that we have probably a half a dozen state parks that are in the top 10 tourist destinations in the state. However, that number that includes day users, campers, and it not necessarily, when you use the word tourism, necessarily means that it's all out-of-state people. These are people, for example, we find that parks in the Upper Peninsula have a higher rate of people coming from elsewhere and that sort of thing. And it's a big deal for the Upper Peninsula because we have people from Wisconsin and when the Canadian borders open and things like that, plus Michigan residents that come. But it's clearly in the high millions of dollars, the tourism aspect of it. But a lot of their numbers blend in golf courses and other things. But we have a fairly good idea, but like I said, we are.
All right, we got to keep moving on. We're running out of time. Rep. Hoytinga, you have a brief question? Sorry, we still have a couple people here, so going to Rep. Hoytinga. Thank you. Go ahead, Rep.
Real quickly, I would
You aren't
say.
going to let me.
Nope, Rep. Young has a question at Rep. Hoytinga. We only have 2 minutes left. Sorry. Rep. Hoytinga, go ahead.
I would just say more than ever, we're in a pandemic. More than ever, people are buying hunting licenses, fishing licenses. Boat sales are skyrocketing. People want to be outside. We're in a pandemic. They want their families healthy. I think the timing of this bill is absolutely perfect. Let our Michiganders stay healthy, get outside, have the first choice. We're not denying out-of-state people. We're not denying them at all, but giving priority to keep our Michigan families healthy, I think is a great idea. Put a sunset on it, perhaps, and then analyze the data, and let's see where this goes. Thanks.
Good idea. Representative Young.
Thank you, Mr. Chair. Yeah, I'm going to piggyback on what the good representative just said, data. I need some more data, and particularly I want to know about these shelter reservations in Detroit with Belle Isle. So if you guys could follow up with me on that to just find out how many are still local, how many may be outside of the city, that would be important for me. Thank you, Mr. Chair.
All right, thank you. Hopefully DNR can get that back to you. Just got a card. I think it's Rachel, and I don't know this last name, Moreno. Does wish to speak, supports the bill. We don't have time for you to speak right now, though. We have to leave. We'll try to get to you later. Seeing no other further business for the committee, we are adjourned.